Get ready for the dictation. Start. Writ petition number 76 of 2016 was filed for declaring right to sexuality, right to sexual autonomy, and right to choice of a sexual partner to be part of the right to life guaranteed under Article 21 of the Constitution of India, and further to declare Section 377 of the Indian Penal Code to be unconstitutional. When the said writ petition was listed before a three-judge bench on 8/1/2018, the court referred to a two-judge bench decision rendered in Suresh Kaushal, wherein this court had overturned the decision rendered by the division bench of the Delhi High Court in Naz Foundation. It was submitted by Mr. Arvind Dattar, learned senior counsel, appearing for the writ petitioners on the said occasion, that the two-judge bench in Suresh Kaushal had been guided by social morality leaning on majoritarian perception, whereas the issue in actuality needed to be debated upon in the backdrop of constitutional morality. A contention was also advanced that the interpretation placed in Suresh Kaushal upon Article 21 of the Constitution is extremely narrow, and in fact the court has been basically guided by Article 14 of the Constitution. Reliance was placed on the pronouncement in Nalsa case, wherein this court had emphasized on gender identity and sexual orientation. Attention of this court was also invited to a 9-judge bench decision in K.S. Swamy and another versus Union of India and others, wherein the majority speaking through Justice Chandrachud has opined that sexual orientation is an essential component of rights guaranteed under the Constitution, which are not formulated on majoritarian favor or acceptance. Justice Kaul, in his concurring opinion, referred to the decision in Mosley versus News Groups Newspapers Limited to highlight that the emphasis for individuals' freedom to conduct his sex life and personal relationships as he wishes, subject to the permitted exceptions, countervails public interest. The further submission that was advanced by Mr. Dattar was that privacy of the individual, having been put on such a high pedestal, and sexual orientation have been emphasized in the Nalsa case, Section 377 IPC cannot be construed as a reasonable restriction, as that would have the potentiality to destroy the individual autonomy and sexual orientation. It is an accepted principle of interpretation that a provision does not become unconstitutional merely because of abuse. Appreciating the said submissions, the three-judge bench stated that certain other aspects need to be noted. Section 377 IPC uses the phraseology carnal intercourse against the order of nature. The determination of order of nature is not a constant phenomenon. Social morality also changes from age to age. The law copes with life, and accordingly change takes place. The morality that public perceives the Constitution may not conceive of. The individual autonomy and also individual orientation cannot be changed unless the restriction is regarded as reasonable to yield to the morality of the Constitution. What is natural to one may not be natural to the other, but the said natural orientation and choice cannot be allowed to cross the boundaries of law, and as the confines of law cannot tamper or curtail the inherent right embedded in an individual under Article 21 of the Constitution. A section of people or individuals who exercise their choice should never remain in a state of fear. When we say so, we may not be understood to have stated that there should not be fear of law, because fear of law builds civilized society, but that law must have the acceptability of the constitutional parameters. That is the litmus test. It is necessary to note in the course of hearing on a query being made, and Mr. Dattar very fairly stated that he does not intend to challenge that part of section 377 which relates to carnal intercourse with animals, and that apart he confines to consenting acts between two adults. As far as the first aspect is concerned, that is absolutely beyond debate. As far as the second aspect is concerned, that needs to be debated. The consent between two adults has to be the primary precondition. Otherwise, the children would become prey, and protection of the children in all spheres has to be guarded and protected. Taking all the aspects in a cumulative manner, we are of the view the decision in Suresh Kumar Kaushal's case requires reconsideration. The three-judge bench expressed the opinion that the issues raised should be answered by a larger bench, and accordingly referred the matter to the larger bench. That is how the matter has been placed before us. We have heard Mr. Mukul Rohatgi, Learned Senior Counsel, assisted by Mr. Saurav Kripal, Learned Counsel, appearing for the petitioners in writ petition number 76 of 2016, Miss Jaina Kothari, Learned Counsel for the petitioner in writ petition number 572 of 2016, and Mr. Arvind P. Dattar, Learned Senior Counsel for the petitioner in writ petition number 88 of 2018. Stop.